Incidentally, before we start waiting, a couple other members are coming over. We have a number of civics teachers in the audience. Would they raise their hands, please?
Oh, my
We have
God.
quite a few civics teachers. I was telling some of them I am delighted to see schools teaching civics and history. It's and when you get done, it might be good for you to come and do a little seminar for the senators. I'm sorry, is that my out loud voice? This morning, see my fellow members here this morning, the Chairman Grassley convened a Senate Judiciary Committee confirmation hearing. It's interesting to have the hearings. I wish we had confirmed some of the people who then voted out. But the glaring omission in the hearing was Chief Judge Merrick Garland. It's been more than 2 months since he was nominated to fill the vacancy on the Supreme Court. In fact, the blocking the way it has is totally unprecedented. He would have already had a public hearing if he hadn't been blocked, would be poised to report him out of the committee. What bothers me is because he does not have a hearing and they're not allowing him to have a hearing, his record is being smeared by outside groups, some of these PACs and others, while Senate Republicans have denied a distinguished jurist a public hearing and a fair opportunity. Now, I can't convene a confirmation hearing. We're in the minority. But just because Republicans refuse to do their job on Judge Garland's nomination doesn't mean that we Democrats will stop doing ours. We take our constitutional duties seriously. And if there's any doubt about the need to have a fully functioning Supreme Court, decisions handed down this week are the latest evidence of the harm stemming from it. The Supreme Court has repeatedly failed to have a decision. They've been tied decision. They've left the courts of appeals below them in limbo because they don't have a full court and can't make a decision. Now, I know that the decision not to give him a hearing was done in a closed-door hearing. This is an open one. And we have 4 people here who know him personally. We have Donna Bucella, whose mother is from Burlington, Vermont. She's a former prosecutor. She worked with Merrick Garland at the Justice Department from 1993 to 1997. She was part of the team that investigated and prosecuted the Oklahoma City bombing, one of the most complex investigations and prosecutions we've had in this country. Justin Driver, Professor Driver, is a professor of law at the University of Chicago Law School. He clerked for the Chief Judge Garland before he clerked on the Supreme Court for Justice Sandra Day O'Connor and Justice Stephen Breyer. And as you know, Professor said, now retired Justice O'Connor said we should be having a full nomination hearing and a vote at Merrick Garland. And Secretary Rodney Slater is a former Secretary of Transportation under President Bill Clinton. He previously served as the first African-American administrator of the Federal Highway Administration, as an old friend. And Judge Timothy K. Lewis is a former judge on the U.S. Circuit Court of Appeals for the Third Circuit. So he knows very well how the circuit courts work. He was appointed by President George H.W. Bush in 1992. I had the privilege of voting to confirm him. He's also served as a federal district judge in the Western District of Pennsylvania. So what I'd suggest we do is probably have each of the witnesses say why they're here. We'll put their full statement in the record, but then if we could then ask questions of the witnesses, and I wonder, and not just because of the Vermont connection or the fact that we're both former prosecutors, but let me call.
You could say because she's a woman.
Because we also have Italian ancestry, so.
Well, Well, and she's a woman and should go first.
Oh, well.
I'll be the last person to argue with Senator Feinstein, who's one of the most valuable members of this committee. Please go ahead, Ms. Bucella.
Thank you. It's my honor and privilege to be here today to talk to you a little bit about someone who I know very, very well, who we work very closely together at the Department of Justice, Judge Merrick Garland. Merrick and I have known one another. We were at DOJ in 1993 through 1997. But I think probably the time we really bonded were the days of Oklahoma City bombing. He and I were out there. We were probably the first people out there from the Department of Justice, excluding the team from the Western District of Oklahoma, the Oklahoma City prosecutors. I got an opportunity at that time to see Merrick firsthand deal with utmost chaos and tragedy, and the entire time just focusing on what needed to be done, that a prosecution had to occur, that the investigation needed to be done in the right way, and to make sure that the rule of law was going to be followed, and that emotions would not take any part of what we were doing. It was an interesting time. It was chaos. Everybody probably wanted to stop what they were doing because it was the most horrific crime on American soil at the time. But we had to go forward. We had to bring the perpetrators to justice. We had to find out what was going on and what had actually happened. We also had, like I had never seen before in my entire professional life as a prosecutor, more tools, more agents, more cops, more first responders, all in one spot, and all anybody wanted to do was to help. And we needed somebody to be the conductor and to orchestrate all that energy, all that smartness, all that brain, all that power to go ahead and investigate the case. And I can answer you plenty of questions with you, but Merrick and I literally, when he got there, we walked the building. We walked through the Murrah building, around the Murrah building. At the time, we walked past the daycare center. Neither of us said anything. We just kept walking. And there were cars that literally were still smoldering in between the Murrah building and in between the Daily Register. There were cadaver dogs, first rescue dogs, then cadaver dogs, trying to find the remains of the people that perished in that building that day. And walking through there, it was more not being talked about. Actually, we didn't talk about it until the 20-year reunion when we were both in Oklahoma City. We finally just talked about it, and both of us had tears in our eyes the whole time. Tears in our eyes did not happen when we were in Oklahoma City. The too much adrenaline and too much trying to make sure that we were doing our jobs for the American people. But there were a lot of people that had very strong personalities, and watching Merrick literally navigate his way to make sure that everybody had a role, everybody had their voices heard, was just something remarkable. Merrick is calm under pressure. You never really know what's going on in his head, and he's always 25 steps ahead of everybody else. And there were some decisions that were made early on in that investigation that, but for Merrick, we could have made a mistake. We could have made lots of mistakes because at the time, everybody just wanted to throw the evidence at us without making sure that our papers were documented and that we had done exactly what was needed to be done in following the rule of law. But I'm going to allow the rest of my colleagues here to speak about Merrick, and I'll be more than happy to answer any questions about Judge Garland and about his qualifications.
Thank you. And Judge Lewis, we've heard that we can't move forward because it's an election year. You were nominated to the Third Circuit September 1992, which was an election year. It's also a presidential election year. You were nominated by a Republican president. There was a Senate, Democrats were in the majority. And we got you through on a confirmation in October of the election year. Am I correct on those dates? You are correct. So would
Yes,
it be?
you are correct.
Would it be safe to say that if the Democrats had given the Republican president nominated you, if we had said there's an election year exception, you would not have been confirmed?
I think it is fair to say that, and I think it's also fair to say that, especially when it comes to nominations for the United States Supreme Court, I have never been aware of an election year exception until this happened. Yes, I was nominated by President George H.W. Bush for vacancy on the Third Circuit Court of Appeals on, I believe, September 18th, 1992. This, of course, was on the eve of the presidential election. It was a hotly contested one, of course, as they all are. And I was unanimously confirmed on October 8th. The election was November 3rd. I am living proof that that can happen. And I am also living proof that the Republic still survives and goes on and does fairly well, I hope. You know, it's also true that not only did the party who then was the majority party in the Senate and obviously on the committee proceed with my nomination and confirmation, as well as others, on the eve of the election, but that party also took the White House. So there was, as I wrote in my statement, really no harm, no foul. And I think that at that time, and this was now 24 years ago, there was a culture of bipartisanship that is severely lacking today. And that's most unfortunate. You know, I come from a wonderful Commonwealth that has produced the likes of Hugh Scott, Dick Schweiker, Arlen Specter, my current Senator Casey. This is so unfortunate to those of us who have witnessed over the years my home state senators cross the aisle, reach out, work to get things done in so many ways. John Hines. And today, we are mired in a very unfortunate and dysfunctional place that is resulting in what is going on now with respect to a wonderful judge, a highly qualified nominee, and incidentally, a terrific human being, Merrick Garland. So you ask why I am here. I am here because I refuse to accept that. And I think that the country should refuse to accept it too. I believe that it is the responsibility of the United States Senate, just as it is the responsibility of citizens of this country to rise above these petty self-interests and to act with honor and with decency. And I think that that is compelled by the very oath that members of this body have taken. I think that we respect values and traditions that are time-honored, such as the confirmation process. Just a hearing, whether or not a confirmation even happens, remains to be seen. But a hearing, the decency to provide a hearing and let the American public view Judge Garland under questioning, vetted fully, at a minimum, is the decent thing to do. Whether it is compelled by law or not, it is certainly compelled by tradition and decency. I am also here because I believe that the United States Supreme Court should never be viewed as a political arm, an ideological arm of any political party. I detest, as a former federal judge and as an American citizen, seeing that occur today. I believe that the Supreme Court must remain above the fray, because it is a symbol of our greatest aspirations as a society. And I believe that we have to do whatever we can, and that's why I'm here today, to help ensure that that continues. So, thank you.
Very much, and I had the privilege of serving with both Senator Hugh Scott and Senator John Hines, and I agree with what you said. And of course, we have former Secretary Rodney Slater, who I mentioned before, and I know we've talked about this and this nomination. So I'll turn to you, Secretary Slater. Please go ahead.
Thank you. Thank you, Senator. Thank you, Senators. I'd actually like to begin with reference to the comments just made by Judge Lewis, because it's interesting that I was making my way to Washington, hopefully, because we were in the midst of a very rigorous campaign during that period, October 1992. And I was working for a young governor from a small state, Arkansas. And for me, just the anticipation of what that journey could be about. It never became clear until now the interesting thread that actually ties us all together as we move across the political process through our system that can take us from one administration to the next, that allows our country to continue to move forward as a beacon of light and hope for democracies around the world. It's clear from Judge Lewis's comments that we gather not for any partisan purpose, but as believers in the Constitution, a Constitution that has caused us all to take a solemn oath to defend and support the Constitution, and has given some of us the opportunity to be nominated by a president and then confirmed by the Senate. That is a very sacred and special process, and it is something to be treasured and guarded. It is also something to be defended. And so in that spirit of just seeing how one administration can move to the next, and a process can go forward to bring one appropriately to a seat on the bench, and another into an administration, frankly, that would have the opportunity to say to Ms. Bucella, thank you, and thank Judge Garland for the work that you did in responding to the Oklahoma City bombing. I was the Federal Highway Administrator during my first stint in the federal government, and we lost 11 individuals, members of our team, who were a part of the 168 killed that day. And it was in that breach of a hollowed-out federal building, of shattered lives, and of grave uncertainty that Ms. Bucella and Judge Garland stepped forward to protect and defend. And so I'm here to say thanks for that effort. I'm also here to say to Judge Garland and to say to all of you that he and I actually have this special relationship with an individual that I'd also like to lift up at this moment. His name is Mr. William T. Coleman. He was the first African-American Secretary of Transportation. He was appointed, nominated, and confirmed during the Ford administration. And so he too came to the fore at a special time. And he gave me counsel when I was going through the process. But he's also a very dear friend to Judge Garland. Interestingly, they both are honored and distinguished graduates of the Harvard School of Law. They both clerked at the Supreme Court, and they both have a fond and committed respect for the law and for the rule of law. And so I lift up his connection as well. And then finally, I'd just like to say this. When my wife and I came to Washington, we didn't know a lot of people. We had a young daughter. Her name was Bridget. And we met the Garlands, who had two daughters, Merrick and Lynn. And their daughters, Rebecca and Jessie, gave us a sense of the place and helped us become comfortable in the place. And so over the years, we've gone to a host of parent-teacher meetings. We've gone to parents' nights. We've gone to sporting events. We have talked about the hopes and dreams and aspirations for our daughters. And so I come also to say that this is a good man. He's a devoted husband. He's a doting father. And he's an engaged and committed parent. And so I'm just very, very pleased to be here in this connected group of individuals to lift my voice in support of Judge Garland's nomination to the United States Supreme Court.
Thank you very, very much. And of course, Professor Driver, as I said, is a professor of law at the University of Chicago Law School, but he has inside knowledge on these. He clerked for Chief Judge Garland, also clerked for two Supreme Court justices, one Sandra Day O'Connor, who was nominated by Ronald Reagan, and the other, Justice Stephen Breyer, who was nominated by President Bill Clinton. So please go ahead.
Members of the Senate, I am honored to have this opportunity to appear before you today in order to comment on the nomination of Chief Judge Garland to be an Associate Justice of the Supreme Court of the United States. As the Senator just mentioned, I had the privilege of serving as a law clerk to Judge Garland on the U.S. Court of Appeals for the D.C. Circuit from 2005 to 2006. Clerking for Judge Garland was an invaluable experience. It was, without question, the most formative single year of my entire career. As has been well documented by now, Judge Garland possesses an unbelievably sharp analytical mind. He works very long hours in order to make sure that his cases come out in the right way. He is, many people have said, a judge's judge, that he's a judicial craftsman of the highest order, and in order to do that, it takes long hours immersing himself in the cases and the briefs, talking about the cases with the clerks in order to make sure that he's reaching the right conclusion. In his approach to the law, he deliberately avoids offering some sort of grand and sweeping pronouncements and instead keeps the opinions narrow so as to dispose of the cases that are before him and to honor the existing precedents. He also makes sure that he never loses sight of the fact that these legal opinions that he and his colleagues produce influence the lives of ordinary citizens. He's very aware of that. So, as I say, he's meticulous in his approach, and nothing better exemplifies that idea than before he would circulate the opinions to his colleagues on the D.C. Circuit, he would have two law clerks, one standing on either side of him, and he would read each word of the draft opinion aloud in order to make sure that everything was exactly right and be open to last-minute modifications. And so that's emblematic of his attitude toward the law. He's also, as I say, measured in his approach to the law. He had an uncommon ability to identify common ground among his fellow judges. He brought people, from different backgrounds, from different viewpoints together as a way of fostering consensus. He dissented very, very few times during his years on the D.C. Circuit. And he has absolutely first-rate demeanor. One of the first questions that he would ask when he would return to our chambers after oral argument would be, "How is my demeanor on the bench?" He wanted to make sure that he was asking tough questions, but that he was also being fair to the attorneys before him and demonstrating respect for these people who were working with him in order to shape our legal enterprise. It's that attitude and that willingness to see people and try to see things from their perspective that has won him a host of admirers who are Republicans, but who are also lawyers, and identify Judge Garland as being someone who is open-minded and fair-minded and demonstrates all of the qualities of being a first-rate justice. Before I close, I want to say just a couple of things about some of Judge Garland's personal characteristics that inspire such deep loyalty among the law clerks. You know, you clerk for Judge Garland for 1 year, and then he stands by you for the rest of your life. You know, there are two instances of relatively recent vintage in my own life that demonstrate that he stands by his law clerks through times difficult and joyous alike. When my mother died a little more than 2 years ago, Judge Garland wrote an incredibly warm note offering me condolences for my loss. When I received an endowed chair at the University of Chicago a few months ago, Judge Garland was among the very first people to reach out and congratulate me on that honor. So through times difficult and joyous, he's there by your side. So the other thing is that, you know, one of the really vivid, indelible images from my time during the clerkship is that right around 6 p.m., Judge Garland I would see him sort of furiously and feverishly packing cases and binders into his briefcase, and then rushing out of the office with a quick good night to make sure that he made it home to have dinner with his wife Lynn and his 2 daughters. There was nothing that was more important than that. He definitely wanted to have the material later in the evening in order to review, but nothing was more important than that. The other thing is, I remember a very early conversation that I had with him. Judge Garland had incisive views about Adam Levine's vocal stylings and Maroon 5, these incredibly sort of insightful commentary about the relative merits of their oeuvre. And I was confused. He's a seemingly staid guy, you know, and he's in his early 50s, but nevertheless, he knows this pop band. And the reason, of course, is because he would drive his daughters to school and at least periodically would allow them to commandeer the car's audio system. And so the lesson to at least this father was that you need to engage your children, at least sometimes on their own terms, and when you do so, to do it with vigor. So by dint of his intellect, experience, temperament, and character, I am confident that Chief Judge Garland would make an excellent Associate Justice of the Supreme Court. Conversely, the failure to confirm Chief Judge Garland's nomination to the Supreme Court would represent not only a grave injustice for this particular nominee, but may also, I fear, portend catastrophic consequences for our constitutional order. Thank you.
Thank you very much. And Senator Feinstein has spoken strongly on this subject and eloquently. And I'm going to yield first to Senator Feinstein and ask, and we'll be joined by Senator Casey of Pennsylvania. And I don't know if you heard the nice comments that Judge Lewis made earlier about you and some of your predecessors. Senator Feinstein.
Well, thank you very much, Mr. Chairman. And to those who have testified today, I just want to say thank you, and specifically to Rod Slater. I can say I knew you before you had gray hair in your head, and I hope it wasn't the federal government that put it there, but it probably was. Welcome back. It's good to see you.
Thanks, Senator.
I would like to ask this question because it's one of the things that has really bothered me, and that has to do with leaving for a substantial period of time the United States Supreme Court in a tied position, a 4-4 position, when we know that the court is divided and what impact that's going to have. And I think there are many of us that estimate that the time is likely to be 1.5 years. By the time you get through the vetting process and all of this, that you can process another nominee. So I wanted to ask the question as to what happens when the court accepts when the lower, what happens when the court is tied and the lower courts are split and is unable to resolve a case? We've seen that already in 4 tie votes, a public sector labor case from my home state, a death penalty case, a state sovereignty case, and a gender discrimination case. And this week, the court essentially deferred on an important issue involving whether religiously affiliated nonprofits can withhold contraceptive coverage from their employees. That's an issue that's vitally important to women nationwide. So I would like to have your views on what happens when you have a 4-to-4 split. Could we begin with you, Professor Driver?
Sure. So the technical answer is that when the court is 4-to-4, that it's affirmed by an equally divided court without setting any precedential value. Exactly as the senator suggests, the result is that a conflict that exists in the federal court remains a conflict. And it's an issue that the court has identified as needing a uniform federal law. That's a major reason that the Supreme Court exists. And that function cannot happen when the justices are equally divided.
Could you explain what does happen when the appellate court has made a decision and then the court is tied?
Yeah, so the result is a lack of uniformity where the courts of appeals have reached differing answers, and it creates oftentimes uncertainty into the law, and that's difficult for all sorts of citizens. I should also say that given the potentially lengthy timeline of an absence, that it could shape the cases that the court ends up hearing. And so the cases that are currently not being decided, in effect, were already in the pipeline before Justice Scalia's death. But during the cert stage, when the court is contemplating whether to agree to resolve a question, one could quite easily imagine a scenario whereby they would say, there's a chance that we could be deadlocked, and in order to avoid that deadlock, there's still a lack of uniformity with respect to the federal law. And the justices have gone to great lengths in order to avoid reaching a deadlock, but sometimes that will introduce more uncertainty into the law for the reasons that you identified earlier, where one attempts to just send something back down without deciding, as we saw in the important reproductive rights decision. The court views itself as articulating generally applicable principles, not merely resolving a dispute between a few parties. And so it seems like a very undesirable consequence.
Thank you. Thank you, Mr. Chairman.
Thank you. Senator Schumer, you
Thank you.
have been very outspoken on this. Please go ahead.
Thank you, and I want to thank the witnesses. I mean, what you're doing is allowing the public to see what we senators who've had a chance to meet Merrick Garland have seen, just what a fine jurist he is, what a fine judge he is, and what a fine individual he is. And the fact that now the public can share some of that, I think, is extremely important. And each of your testimonies really was powerful in regard to that. It's a shame my Republican colleagues, especially those who did not sit down with Judge Garland, aren't here to hear that. There's only one benefit. I can go immediately after Senator Feinstein. We don't have to alternate to the other side. But I'd trade that away in a minute for hearing, for them being here and having a real hearing. One of the things I'd like to focus on is what I have learned about Judge Garland, his ability to bring different sides together and unify an opinion. He has the reputation, at least, you all would know better than me, of being a great listener. He's a really brilliant man, but he listens. He doesn't make up his own mind and then try to push people in that direction. And This is particularly important this week to think of being a unifier because we're celebrating the anniversary of the historic Brown v. Board decision. Obviously a very contentious case, but due to the efforts of one of our greatest Chief Justices, Justice Earl Warren, was handed down unanimously, and that helped move the nation forward and heal the nation. So the importance of personality on the court is really important, the importance of a personality to find consensus. So first, let me ask you, Judge Lewis, and by the way, you were to show you the breadth of this, as I understand it, Judge Lewis, you testified on behalf of Judge Alito, who was one of your colleagues on the Third Circuit, when he had his hearing, even though I believe he was nominated by George Bush. There was no attempt to block it or hold it up, and you were there as a witness for him. Is that right?
That's right.
But what I'd really like you to talk about a little bit as a fellow judge, give us a sense of how Judge Garland brings people together, and again, then to Professor Driver, the same, as his clerk, how his storied, unique ability to do that. If you could elaborate on that so we could hear it.
Thank you very much, Senator Schumer. I especially thank you for reminding us that this is a period of time when we celebrate the Supreme Court's decision in Brown versus Board of Education, which was handed down in the year of my birth, 1954, and has thus played a very significant role throughout my entire life in many different ways. And I say that for more than just the fact that we are observing it this week. I first met Judge Garland at the home of one of the key advisors to the legal team, Justice Thurgood Marshall and others in that case. I was at Bill Coleman's home, and Bill Coleman was hosting a dinner to honor the integration of the federal judiciary. We were there, he and I were co-chairing an event that was held here in Washington. It was a biennial gathering of all of the federal judges of color called Just the Beginning, and we were hosting a dinner. He was hosting a dinner with some people, and Merrick Garland was my dinner mate. He sat right next to me. We had a wonderful conversation, got to know him then, and of course, in later years, I obviously followed his work on the court, and to answer your question directly, was especially impressed with his the number of unanimous decisions that he authored, which, as you pointed out, is an indication of a consensus builder. And consensus building was at the very core of the meaning, the importance of Brown versus Board of Education, a unanimous decision. The Chief Justice demanded that it be unanimous and did everything possible to ensure that that would happen because he knew the import of that case and what it would mean for the country. Now, why is that also very significant to why we are here today? On Monday, the Supreme Court issued the Zubik opinion, which we've talked about. Forgive me for calling that a compromised decision, but that's how I view it. Just imagine for a moment if during this period of a 4-to-4 split on the court, Brown versus Board of Education had come up. Think about the implications for the nation if that case on Monday was Brown versus Board of Education. Think about that. As an African American and as someone who is and has always been committed to issues of social justice and civil rights, I can't help but think about that. And I can't help but think about it in the context of other cases that are bound to appear to come up to the court during this period. Senator Leahy, I am glad that you pointed out that we have some civics students seated behind us here today. I hope they are learning something, but think of the lesson that where we are at this moment in connection with this nomination is teaching them. These are matters that should be of critical importance to all of us on both sides of the aisle. The future really is at stake. These kinds of decisions that were issued on Monday have real consequences. In Brown versus Board of Education, like the Zubik case, you had decisions in one part of the country that went one way, and in Delaware in particular, my former colleague on the Third Circuit, Collins Seitz, was the chancellor of Delaware at that time and was the only judge who was affirmed by the United States Supreme Court in that case. But imagine if the court said, you know, we're going to punt on this and hope that you all will just work together and figure it out. So that in one part of the country we have people continuing to pursue one set of policies, and in another we have another. These matter. These matter. Elections matter. The duly elected President of the United States has nominated a highly qualified person to a position of great importance. That matters. Not the future president, this president, with almost a year left, nominated Merrick Garland to this point, to this position. Elections matter, decisions matter, and the Supreme Court is a wonderful piece in this morning's New York Times by Adam Liptak about the marginalization of the Supreme Court as a result of this effort. And I just hope, and I join you in wishing that some of your colleagues across the aisle were here today to understand this and to hear this. There are real consequences affecting real people. Some of these are matters of life and death. I don't know if you're familiar with the case of Dwayne Buck. Dwayne Buck is an inmate in Texas on death row who was sentenced based on testimony that he posed a future danger because he was black. And that issue, whether one's race can be considered a future danger, in Texas you have to establish future dangerousness, can be taken into account in determining eligibility for the death penalty, is now before the United States Supreme Court on a cert petition. This is the 5th consecutive week that the court has not acted in conference, declining the petition or accepting the case. These are matters of, he's sitting on death row wondering what's going to happen. And there are others. So it matters a great deal, Senator, and thank you very much for the question.
Very. One of the members of our panel is several of us are members of the bar of the Supreme Court, but he's also been the Attorney General of his state and U.S. Attorney Senator Blumenthal. Please go ahead, sir.
Thank you very much, Ranking Member Leahy, and thank you for having this hearing. And I must say there is a lot of history and wisdom and insight and eloquence on this panel, and I'm deeply respectful of each of you for your public service to our nation. But if I may say so, you're no substitute for the real thing.
We understand.
I think you would agree.
We agree.
And this hearing is no substitute for the real thing. We should be talking not about the damage to our justice system that results from the refusal to have a hearing and a vote, but about the qualifications of Judge Merrick Garland with Judge Merrick Garland in the place where you are sitting now. That's what the American people deserve. And I think, Judge Lewis, you made a very telling point that there is damage to the court and to our justice system from the politicization, dragging the court into the mire of partisan bickering, which has infected this place, much to the consternation of the American people. I was a law clerk to Justice Harry Blackmun, and then U.S. Attorney and Attorney General of our state, and I've argued 4 cases before the United States Supreme Court, and I have a deep respect and reverence for our judicial institutions. They should be above politics. And I am deeply saddened by the, in effect, polarization politically of views on the confirmation process and the refusal of our colleagues on the other side to do the right thing and to do their job, and instead to obstruct this process. And I think the effect is not only 4-4 deadlocks, but to use the very apt phrasing that you cited from the New York Times article this morning, the court is not so much deadlocked as diminished, because the effect is not only to fail to resolve splits in the circuits, but also to duck issues, as they did in the ruling in Zubik, and also to fail to take cases and resolve them. And I spoke yesterday on the anniversary of Brown v. Board of Education on that anniversary, but also on the effect of the court. And I have no doubt that Brown v. Board would never have been decided unanimously with a 4-4 court. Given the history, and we know more about the history now of what Earl Warren did in that court, the dynamics would have been totally different, and the dynamics now in the court are totally different. And the effect is to marginalize the court, diminish it as a branch of government, which in turn diminishes our democracy. And so I think we owe it to the American people to move forward with a hearing and a vote on a man who has superb, in fact, impeccable credentials. I would like to ask you, Mr. Driver, and I have known Judge Garland for many years. I first met him when I was U.S. Attorney decades ago. When he had a hearing in a case, and I think you mentioned it in the letter that you and other clerks wrote, did he come to the hearing and make a decision based on a predetermined point of view, or was his mind changed by what he heard, what he read, what he exchanged with you, his law clerks?
Yeah. I would describe Judge Garland's attitude and approach toward cases as being very much bottom-up rather than top-down. And by that I mean he does not have some sort of overarching, judicial ideology that he is imposing on the facts of particular cases. Instead, he is committed to reading the binding precedents and the briefs and the record and immersing himself in those materials in order to reach an appropriate outcome. And I think that that is a big part of the reason that he's been so successful at fostering consensus. In addition to his temperament of not sort of demonizing people, I never heard him utter a disparaging word of any of his colleagues on the D.C. Circuit or any other of the lawyers that appeared before him. And so I think that it's not that he sort of had those thoughts and was muting himself. Instead, there's a certain generosity of spirit that one sees with Judge Garland. And so the immersing himself in the materials allows him to identify points of commonality for himself and two other people who were on the panel. And so people should not think that the relative lack of dissents are indicative of someone who's trying to sort of cut a deal or sacrifice his core judicial principles. That's not the case at all. Nevertheless, he is able to identify points of overlap and commonality as an effort to have the court speak as a court rather than three individuals who are just sort of offering their own views. So I think that's why he's been so successful at fostering.
And someone who believed most deeply in the rule of law, as he has said.
Yes, absolutely.
Thank you. Thank you, Mr. Chair.
Well, thank you very much, and we've talked about Pennsylvania, and especially you have Judge Lewis, and brought back great memories of many I've served there. One I'm very proud to serve with is Senator Casey. I am proud to serve. I've told him before that my father, This is on the Irish side of the family. Mr. Sullivan, my father was a huge fan of Senator Casey's father when he was governor. Senator Casey, go ahead.
Well, Senator Leahy, I want to thank you for that introduction. I'm referring to him as Senator Leahy instead of Chairman Leahy because this is an unusual forum. It's a public meeting, not a hearing. It's so unusual that a member of the Senate who's not a member of the Judiciary Committee was allowed to parachute in, take a seat where the name card initially was Senator Whitehouse.
He didn't ask unanimous consent, Senator.
So Senator Leahy, I want to thank you for giving me this opportunity, and I want to thank the panel, because if you didn't show up, I wouldn't have this opportunity that would give my mother and my wife pride and would cause concern to my three brothers who are lawyers. But I won't have a long question. Just a brief statement, and I'll direct my question to Judge Lewis. I want to thank you for not just being here today and your testimony and your commentary, but also for your great service as a member of the Third Circuit. And I wasn't here when you were confirmed, but I'm struck by how different the process that led to your confirmation was compared to this one we're talking about with regard to Judge Garland. What struck me about Judge Garland, the obvious attributes that you would hope every judge or justice would have: sterling academic credentials, the kind of character and experience you would want in a judge or a justice. In his case, a combination of being a lawyer, a prosecutor, and a judge, just a remarkable range of experience. So all of that was impressive, obviously, in his demeanor and his character. But what was interesting to me in meeting him for the first time and sitting in my office talking to him were two things that might be unusual for a judge, might be ever more unusual for a public official: humility and gratitude. The kind of humility that I think is consistent with what you said, Judge Lewis, in one of the statements you made. I think it was with regard to the confirmation of then Judge Alito, about no one having a corner on the marketplace of ideas and about what is right, and that theme that you struck there. So that kind of humility that even with all of his academic training and experience, that he doesn't have all the answers, but also the humility to listen to other people. And secondly, gratitude. I've never met, or maybe rarely have met, someone who is more grateful for the opportunity he had to serve as a prosecutor and to serve as a judge. Talk us through how those attributes, in addition to the others that I mentioned, are critically important to have on the Supreme Court, even though that word supreme would lead you to believe that there's no need of humility.
Well, thank you. Thank you very much, Senator Casey. It's always good to see you, certainly good to see you here today. Well, you have touched upon the two qualities that, for me, are the most important for anyone holding any public office, but in particular for a judge, and perhaps even more so for a justice on the United States Supreme Court. I'll explain this by telling you about why I testified on behalf of Justice Alito, then Judge Alito's nomination to the Supreme Court 10 years ago. I had worked with him for a number of years on the Third Circuit. I found him to be intellectually honest. I found him to be a person of both humility and gratitude, and all of the other qualities that I think go into making a good judge and a good justice. We disagreed on a lot. We disagreed many, many times in very key areas. We did sometimes join one another in votes, some of them in matters that might surprise people, employment discrimination matters, very significant ones, and some other cases. He was willing to go along with or to join a majority where it may have appeared to be inconsistent with his jurisprudential approach, which was one that was steeped in a far more conservative one than my own. But he was nominated by the President of the United States, and he clearly had all of the qualifications necessary to serve on the United States Supreme Court. An excellent educational background, terrific record of service to his country in the Solicitor General's office and as a U.S. attorney, and then as a judge. And I did not believe, and I do not believe, that the mere fact that I disagreed with him ideologically should stand in the way of my standing up and saying, yes, of course he's qualified to be on the United States Supreme Court in my view. I don't think that a monolithic court that reflects everything that I believe in is appropriate for the country. I am very much in favor, and I think that it is one of the best features of democratic government that we have a multitude of views that go into the judicial decision-making process and the legislative process. It's very important. And the capacity to reach across the aisle or the bench in order to do that and to do it well is critical. And I had observed that during my work with then Judge Alito. And so I believe that Judge Garland reflects that in volumes. As I've mentioned before, the fact that he has been a part of so many cases that have resulted in unanimous decisions is an indication of his capacity to do exactly what I'm describing. It's so important. Corporate decision-making, if you will, group decision-making at that level requires a capacity to be selfless and to instead look out for the interests of the parties and the litigants before you, and also the United States of America. And so the record that we have with respect to Judge Garland is exemplary when it comes to the qualities that you mentioned. And I think that these are not just personal traits, these are traits that we have to bring with us to the important work that we do on behalf of the nation. Thank you.
Well, Judge, thank you, and I want to thank the panel. I know I was late for the other comments that you made. We're grateful you're here and appreciate your ongoing public service, and this work you're doing today is public service. And I want to thank Senator Leahy for leading us in this effort to focus on the qualities, the attributes, and the experience of Judge Garland, and not just being the chairman of the committee, but being committed to what I think is in the Beatitudes, Senator, which is hungering and thirsting for justice, which is one of the reasons he does such good work as our chairman. Thanks very much.
Well, I thank you, and I thank you very much. And I know you and Judge Lewis have known each other for a long time. And I want to thank all four members of the panel. What we wanted to do on this, obviously not a hearing, obviously it's not a substitute for a hearing with Judge Garland, but those of us who've known him for a long time, and I've known him for a very long time, we know of his qualities. I get frustrated when I hear some of these lobbying groups going attacks against him. Of course, he can't respond to those. He can't respond to them. If he had a hearing, of course, he could be asked the questions, and knowing Judge Garland as I do, he have answer to all of them and swat them down. So what you've done, the four of you, has spoken to the quality of a good person, a very, very good jurist, one that any of us who are in court, whether we're a plaintiff or defendant, no matter which side we're on, we would feel comfortable having him as the jurist there, because you know you'd have a fair hearing. Ms. Bucella said it'd be very easy to say, oh, we got the, to quote a former person, the guilty accused here, the worst expression I've ever heard, but instead what you and Judge Garland did in Oklahoma City was to cross every T and dot every I, as prosecutors should. And Judge Lewis, I remember very well your testimony, and you were very honest and forthright then as you were here today. And Secretary Slater, when you spoke of former Secretary Coleman, I think of all the times he's been in my office, always speaking on behalf of others and what we should do, never asking for anything for himself, but telling me about good people in both parties who should be considered. And obviously you know him that way. And Professor Driver, I was fascinated by how you talked of the way Judge Garland would handle cases. It must have been a pretty exciting time to be a law clerk with him, and I think probably it was a great way to prepare for the chair you now have. So I thank you all very, very much.
Thank you.
And I thank the members for your
Thank you, sir.
Thank you.